figure it out. Oh, I know one of the things I've forgotten. I'll mute this. Oh, there we go. Got it. Yep, got it in time. Right, hey, right, guys, bear with me a sec. What's to do the old admin here? There's that. Let's pin that message and go here. What's going on here? That's weird. That's better. Right, cool. Yeah, welcome everyone to this week's live stream. I got sunburnt this week, but I'm not complaining. Working outside, which is all very good. Hope everyone's well, or as well as you can be, given that you're coming to a Homelessness all live stream. So, yeah, usual stuff. This is not legal advice. We're doing our best here to give a helpful answer. Some of the questions are very interesting this week, so we'll see how we get on with them. And also, if I could just remind everyone not to put any personal data in the chat, and that includes questions that are posed in the first person. So if your question is, I'm currently in TA, what happens? I will delete that comment and ask you to rephrase it and ask it as a what if question. You'll get exactly the same answer. In fact, you'll get a better answer, and you don't have to spew your data all over the net. Also, I'd say if you want to give the video a like or whatever, that'd be awesome. Just to help the old algorithm. I think that's it from me. Any gossip from you guys? Any news at all? Anything useful going on in the world? I'm playing the game of what's Trump done now. So see what he's. It's such 145%. I've just checked. But yeah, who else knows what's happening? But in the world of homelessness, I'm not sure what's changed this week.
I'm feeling good because I won a homelessness appeal today, which
Nice.
yeah, but it was made easier because the council didn't turn up for the hearing. But
Deliberately or like because they
no, I
forgot?
think they just forgot about they just screwed up. But I was worried that I said to the barrister, you know, the county court judges are so predisposed towards the local authorities that they may even find for them without them turning up, but they didn't. He didn't.
How did you get on in the one last week? Because I remember you were a little bit nervous about that one as well. On Friday, was it? With the judge, the
Yeah.
judge that was involved in Assange.
Yeah, well, he's given a reserved judgment. I mean, he sounds like he's not going to give us much. I think he's going to find against us, but you never quite know because the argument. I think our argument. You never know if they're fight. He was making lots of disparaging comments, but sometimes they do that as a sort of way of then they find for you, and the other side won't say, "Oh, you were, you know, you never gave us a chance." But I think we'll get a decision in about 3 weeks, and so I think we'll be off to the Court of Appeal at that stage. Very nice guy, but just completely. The thing was as well that the court had said before that they should list a judge with court of protection experience because it's a vulnerable client, and this judge he had so little court of protection experience. He was sort of questioning what orders they could make. So I don't know quite what went wrong there, but it might help us with the appeal.
Yep.
So yeah, but that's about all my gossip. But speaking of Trump, there's a really good book I just started reading. It's called All or Nothing, and it's the story about how Trump got back in, and it's beautifully written. It's
Is that by Michael Wolff?
No, it's by somebody called Michael Wolff.
He's written like 4 books on him. It's quite interesting listening to him. He basically says that forget like what Trump's strategy is. He just wants to be in the news. That's it. That's his only objective.
Yeah. I mean, they've said the beautiful expression he used was he said Trump is a deranged comedian with a rapt audience. And I thought that's a good way of summing him up, really.
Yeah. Cool. Okay. Right.
To
Oh gosh, Annie. Yeah.
interest. Nah, just it's not. It is homelessness, but I went to an interesting webinar by Joseph Rowntree Foundation and Frameworks, and it was about like how to build consensus for building homes. And it's stuff that we think about and talk about all the time in terms of like housing officers and how on earth do we get public on side. And of course, it's all about framing and whatever. But it was a really interesting webinar about like the research into because they do frameworks does lots and lots of research into people's beliefs. So not necessarily what they think, but like what underpins that. So yeah, I just
Is it
if people want
recorded?
to check out. So it was recorded and it's going to go up on their YouTube. So I'll sort of let people know when it's up. But there's some good resources on there in terms of if you're a worker in the sector and you're trying to influence or make change, knowing actually where it's all obvious, isn't it? Like we all know this, but like something about having it sort of said to you quite black and white was quite helpful. So yeah,
Cool.
that's my only sort of news.
No, that's cool. That sounds good. Yeah. So what? And Joseph Roundtree. I'm not subscribed to either of those organisations' channel, but I'll check it out. I'll figure it out. We'll figure it out. Cool. Yeah, let's get started. I feel like I've forgotten something, but I don't know what it is. So we'll just proceed, and maybe I'll remember it in a minute. So in fact, the first couple of come on Zoom. First couple of bits are actually more of a comment rather than a question, but I thought they were interesting nonetheless. So am I sharing that? I'm not sure I'm sharing the right screen now. Hold on, let's share that again. I was. Okay, cool. So yeah, first one was just on the video about ChatGPT, and this person said that they used it for Section 202 review recently as well, got the decision quashed or overturned, I guess technically. Also used it to handle the complaints procedure, which is currently escalated to the LGSCO. So I'm more confident than ever that ChatGPT is going to be capable of writing meaningful complaints and challenges, Section 202 challenges and so on, which is all good. And then an interesting one as well, which I don't think we've got enough time to really explore, but I just thought just made a really interesting couple of points really. Okay, I'm not sure what I think this video was about vulnerability actually. So I find, yeah, it was. So yeah, I find Johnson, that's one of the cases we discussed, interesting because many people with trauma and substance use avoid NHS services for good reason. They've been treated badly and not believed, so are less likely to have diagnosis in the first place. And then someone commented, I agree, but even with the diagnosis for trauma, it's usually pathologized and then used as an excuse to exclude from all services, including homelessness prevention duty, etc. So many of us avoid NHS services because of the re-traumatisation of not being believed and being treated badly. It's dystopian. And I thought, again, as I say, it's a shame we can't talk about that in more detail, but I think there's a lot in that in terms of both comments and just probably highlights the fact that I think as a society, we are absolutely almost useless at kind of understanding these kind of terms, what they really mean, and just kind of like, yeah, thinking there's some magic label or something that kind of means certain things that it probably doesn't. But yeah, I just thought I'd throw that up there. Let me just turn this, switch this off a second. What do you want to do that? I can make, yeah, collapse ribbon. So yeah, anyway, on to the questions. So first question, very quickly, and again, I'm just dropping this on you guys because it came in, well, it didn't come in last, I remembered it last minute. So it's about whether someone can be barred from a housing register when their rent arrears is more than 6 years old. And I seem to remember, and this person has done some research themselves and seems to kind of suggest what I'm thinking might be right, in that that council policies can't hold rent arrears against someone for more than 6 years because there's like kind of almost like a statute of limitations type thing going on. Now, I know some policies specifically state that, but other policies don't. But I just wondered if either of you guys knew whether there's something which overrides local policies when it comes to holding someone's rent arrears. I mean, I don't know how much it is. I'd assume it's probably four figures. But basically, whether someone who's got the really really old rent arrears can actually be barred from the housing register if making like not a homeless application, but if they're just making a Part 6 application. So I'll quickly open it up to you guys in case you might know. If not, I will go to the next one. As I say, I just dropped that one in the last minute.
I don't know the answer to that one.
No, that's cool. Okay, so next one is an absolute monster. And what I'm going to do is question regarding flooding. And then I'm going to switch to another screen, which has got the full question. And usually I wouldn't share questions this long, but it's kind of, it is concise and it's just has a lot of interesting stuff in it. So, I mean, basically, oh gosh, got to do it here as well. Stop doing that. Hold on. Yeah, so basically, I'll start reading it out and then probably make some comments in a moment and just collapse this one as well, just make it a little tidier. So British national initially approached the local authority, which is Worcestershire, or in Worcester, I'm not sure if it's Worcestershire or Worcester, for homelessness assistance when her home became inaccessible due to flooding in the village on day 0. Again, the dates were given in the question, but I've anonymised it, resulting in evacuation. The authority provided temporary accommodation whilst determining when it would be safe to return. However, before the village reopened, because the whole thing was basically shut off, the client surrendered her keys to the landlord, citing inability to afford the rent and mental health concerns relating to the ongoing flooding issues. And then this is immediately where there's potentially some issues here. So a section 184 letter dated 3 weeks later accepted a relief duty and stated that your property address was no longer safe to occupy due to the village being flooded because of adverse weather conditions, and you have no other accommodation available to you which you have a legal right to occupy. And then went on to say, we are satisfied you have a priority need for accommodation in accordance with Section 189 because of your property not being habitable due to a flood. Now, this is, I'm probably going to start asking or answering questions as we go with this. This to me says something's wrong here, because potentially there's an issue that the letter's been called a Section 184 when it's not really. It might just be a letter, maybe a Section 189B letter or something like that. But basically, a council shouldn't basically be being fined someone in priority need within the relief duty. And we're talking here, we're still within the relief duty. So although they can say they're satisfied the person is homeless and eligible, which this person would have been whilst the property was flooded, I don't think they should have reached a conclusion that the person was in priority need at that point. That then leads to some more issues. So when the village eventually reopened 5 weeks later, so we're still talking within relief period here, another residents returned to the homes. The housing authority determined that whilst the client met the definition of being homeless, she no longer qualified for priority need status because the emergency accommodation had been resolved. Now, this is it's a little bit confused here, but as in the order's a little bit out. But essentially, she gave the key. Sorry, did it already say that? Yeah. Oh no. Yes. Yeah, so it does say that. So the client surrendered their keys to a landlord. So she no longer qualified for priority need status because let me just zoom in a bit as well, just make it easier to read. Had resolved. The authority concluded the client's decision to surrender the property was made with full awareness of the consequences. The applicant received a minded to find intentionally homeless letter 8 weeks later, which stated that you left your property at the address after the village flooded in October 2024. I might be getting that date wrong. Again, I've kind of just tried to work out where this was. However, when the village was safe for residents to return to their homes, you gave your keys back to the landlord, stating that you could not afford the rent. Once the village was safe to return to, the property was available to you, suitable for your housing needs, and been assessed as financially affordable for you. Housing authorities now issued a decision finding no priority need. So this, I think, is correct, because the decision, whether someone's homeless, whether they're in priority need, whether they're intentionally homeless, that's basically that needs to be true on the date the decision is made, not the date on which the homeless application was made. So obviously a lot can change in 8 weeks. So for example, you could be homeless on day one because your property's flooded, but then if you can then return to it because the flooding's receded and you've kind of, your property's been fixed up or whatever, and then the decision's made 8 weeks later, then the decision can be that you're no longer homeless. So the council said, well, you're not homeless because of flooding anymore, so you're not automatically in priority need. There's issues around kind of vulnerability around some mental health issues that are kind of listed as well in the question, which I think I might have taken out here. You approached the Council for Homeless Assistance on day 0 due to your home not being accessible to you due to severe weather, causing flooding at the address, resulting residents have to be evacuated for their safety. You advised me on day 48 that you handed your keys back to the landlord the day before without consulting housing options due to not being able to afford the rent and your mental health suffering, rendering yourself homeless. Sorry, this is a little bit garbled here, but I'm doing my best. It seems from reviewing the decision letters that the council have changed their mind about the reason the applicant had a priority need. This can't be right, surely. So this is the professional asking the question. Yeah, it then goes on to say, if a person becomes homeless initially due to an emergency and therefore establishes a priority need but subsequently surrenders their property before they could return after the emergency has ended, can the council change their mind that the client has a priority need? So I think the answer to that is, and I'm looking at Shannon and Will slightly here, but I think the answer to that question is that they can do that, because the problem here in this situation is that the council shouldn't have written earlier on in the process that this person was in priority need. Sorry, this bit here. That was not for them to say at that point. They were homeless at that point, but the priority need decision can't be made within that 56-day period. So somewhere in the Code of Guidance, it says that local authorities are advised against issuing a a letter accepting the main duty. That I'm paraphrasing that, but that's what it says, within the relief period. So essentially what's happened here is the person was homeless because of flooding. There's reason to believe they might be in priority need, so they're provided with interim accommodation, we're assuming. But then the homelessness no longer kind of continues because of the flooding, but now they're homeless because they've given up the keys voluntarily, in effect. That's what the council's saying. And so they lose their automatic priority need status because they're no longer, on the date of the decision of the Section 184, which should have been at the end of the relief period, they're no longer automatically in priority need because of the flooding. It leaves open this question about whether their mental health issues might render them vulnerable, but that's more difficult to argue. And we've now got an issue where the reasons for her being homeless is no longer the flooding, it's that they gave up the keys. And again, that there might be an argument against them being intentionally homeless if it was in fact unaffordable, because just because the council said that they've assessed it as being financially affordable doesn't mean it is. Could be just kind of a poor quality assessment or whatever done there, or just a template letter. So I think that potentially the council, although they've made a clerical error in writing this sentence here when they shouldn't have, I think they would be at liberty to write a Section 184 decision at the end of relief period saying that they're homeless, that they're not automatically in priority needs. As I say, the assessment of vulnerability might have been wrong, so that there might be grounds for a Section 202 review for this, and that they are intentionally homeless because, and this is another interesting bit here, the reason for them losing their home was the giving up the keys, not the flooding. And so, again, it's an interesting side question, really, which I don't think applies here. Is just kind of how flooding, kind of the fact that you can be homeless and then not homeless because the property is no longer flooded, how that might actually affect a decision. But anyway, I think that's my answer. I think the council could actually be following the law here, but it's possible they've made basically a poor decision around vulnerability and potentially a poor decision around intentional homelessness if they haven't correctly looked at affordability and the impact on the person's mental health. Because I guess another thing that might have happened is that obviously this would be very overwhelming. The person might essentially, they kind of had a really kind of poor spell of mental health and made a kind of an irrational decision, but it was sparked by really poor mental health at the time. So that's also possible. But I think both of those, the answer would be challenge it through Section 202, and that there isn't any kind of de facto mistake the council's made, like definitely. But as I say, really interesting situation. I'm interested to hear if Will and Shannon have got anything to add or take away from that.
I mean, I think I could see Will about to talk, but I'll jump in because mine's probably less useful. But I think if this was my case, I'll be honest, I'd probably make a fresh application to sort of try and start again, and on the basis that the vulnerability probably hasn't been assessed correctly, and based on that new information, really. And I think there were the whole what they were homeless for is interesting because they probably were homeless because of unaffordability. The house or whatever probably flooded, and then they went, oh my god, I definitely can't afford to fix any of the damages with the flooding, or this is so stressful, and I think that sort of good faith intention comes into things there as well, like in regards to the intentionality. But yeah, I think if it was my case, I'd potentially, instead of challenging through 202 reviews and stuff, I'd potentially make a new application either to the same borough or a neighbouring borough.
What would the new information be? Because I guess there's
evidence on the mental health.
Yeah. Okay. Yeah. That's that. I mean, I think but essentially that's that kind of breaks away from the complexity of it all, as you say. Yeah. Okay. That's so there might be a case of actually either kind of requesting further information from treating professionals or potentially the client going to their GP again just to kind of get an up-to-date assessment if there's not been one recently. That might provide some new information as well.
And even from the landlord, I can't imagine a situation where someone hands their keys back to the landlord because it's unaffordable after just having a flood and they seem chill. Like, I can't imagine sort of, or they might be weirdly chilled and sort of be like really logical about it. But I think, yeah, I'd start trying to get together that evidence of their mental state or capacity or whatever when they made that decision, but also just their mental health in general, and some more financial information.
Yeah, yeah. Okay. Yeah, I mean, I guess if there's further information about mental health issues that wasn't considered in the original decision, then you effectively get to play that, you get to have that argument again with the intentional homelessness. So, which again, kind of, you've got that fresh opportunity to kind of lay that stuff down. Yeah, okay. Will, did you have anything to
No,
add to
no,
that?
I think I agree with Shannon there because I think the council are able to get away with what they've done here. It seems a bit messy, and I agree with you that there was no need for them to talk about priority need in the relief duty letter. They could have simply said, we're giving you temporary because we've got reason to believe you're in priority need. I was looking at the question of whether the council was somehow bound to treat her as being in priority need because she became homeless due to an emergency. But the wording in the Code of Guidance at paragraph 8.3K refers to the present tense. So the person is homeless or threatened with homelessness as a result of an emergency. So if
What paragraph was that, Will?
that's paragraph 8.3 bracket K.
Okay, I'll find it whilst you're talking.
So what that says is you're entitled to priority need if you're homeless as a result of an emergency. So what the council could probably get away with saying is you may have been homeless as a result of an emergency when we accepted the relief duty, but now we applying the same test, we think the reason you're homeless is because you've voluntarily given up the property. And it was available for you to return to. The emergency had ended. I don't, and as Shannon says, I think we then need to look at whether the effects of what she went through may have pushed her over the edge in terms of not being able to go back there. And then, yeah, I mean, then there's arguments. Intentionality is sort of talked about, but not really explored in detail there, is it?
No, I think that, I mean, that there's a bit more information which I kind of took out of the text, but I think I've done justice to the original question. As I say, I've kind of anonymized it and taken some bits and pieces out, but I think that kind of kind of means that we've given a sensible answer. I mean, the person who's asked the question, feel free to come back to us and say, you got that wrong, got that detail wrong. But I think it sounds to me like, the situation is just calls for mental health, kind of focus on mental health issues, getting evidence, getting fresh assessments, and then making a fresh homeless application, and then having the argument about intentional homelessness that time. So but interesting one, interesting question. And it's good to kind of explore. I appreciate there's not many people in that situation, but it's kind of, I guess it's helpful just to kind of hear, kind of us talk about how this all works. So next question, and bearing in mind, guys, I am prioritizing questions which have been anonymized. We'll do the non-anonymized questions from the week at the end, if that makes sense. I'm struggling to use Zoom. There we go. Right.
On that note, there's someone on the YouTube channel. If you just word it so it doesn't say I, just say my friend, then we'll be able to answer your question. It just saves you from putting your personal information in the chat.
Yeah, cool. Thanks. I'll just gonna remove them. Yes, Shannon says just rephrase it. I mean, again, I know it seems really annoying that we're doing it. Hey, right, shouldn't it? Really annoying that we're doing that. Well, really annoying I'm doing it because I just appreciate. It's just me being pedantic, but I promise you, there's good reasons for it. And it's just about kind of separating out the legal question from everything else someone's got on. Actually, can be a really helpful thing, and also protects people's data rights. So question 5, after the 56 days relief duty is up and the council says the person is still in their original, and say the person is still in their original accommodation waiting for eviction via bailiffs, which could take more than 2 months. The 56-day relief duty is up and the council have said the person has no priority need despite meeting the criteria under medical grounds under the housing legislation, section 189. Is it hopeless as the 56 days relief duty is over and bailiff still hasn't happened yet and can take up to another 2 months until they arrive? meaning the council have no legal duty to help the person anymore and they're evicted after the relief duty ends and the council say the person is not in priority need. It's a no-fault eviction and the person has a connection to the area as they've lived there most of their life. The person is working, receives no benefits and can't get legal aid. However, the person can't afford to rent in the private sector and due to medical issues, the person can't house share. What would you advise that person? Okay, so first thing I'd say as a bit of a, it's not a throwaway comment, but just something that's going to help is there's a video on the channel called What If You're Not in Priority Needs? And I'd say check that out just because it's good to understand what the council's duties are if you're not in priority need. One of the reasons priority needs is so important is that a lot hinges, whether the council's got a duty to put a roof over your head hinges on priority need status. And I'll say a little bit more as well. So when it comes to priority need through medical grounds under housing legislation, just bear in mind it's never kind of black and white. So you might read the list under section 189 and see your own condition kind of effectively covered. That is not enough to show that someone's in priority need through vulnerability. You have to formulate your evidence in a certain way. And we've done extensive videos on that. I put a video recording me and Will from last year actually up on the channel this week. But we kind of talk about how it is you need to present your case. And so a lot of people who are genuinely in priority need through vulnerability approach a council, but the way the evidence is presented makes it very easy for the council to work to make an incorrect decision. And so in a nutshell, whatever your kind of condition or your impairment, to use the word of legislation, is, you need to essentially focus on what is going to happen to a person if they were to become homeless. Sometimes it could be very obvious. So if they've got arthritis, for example, and they become homeless, then their joints are going to get very painful and probably swell up because of the cold. That's a really straightforward case. You then need to essentially compare that to what would happen to a hypothetical healthy and robust person without that condition. And then you need to kind of work out what harm is going to result. And so it's a really convoluted way of working, but that's what we've got. And so that's what you've got to do. So in this situation, what you'd really want to be doing is you'd want to be asking for a review of the non-priority decision through the Section 202 process. I seem to have just frozen. I'm not sure if I have or not, to be honest, but yeah, okay, cool. So that's the thing. Now, additionally difficult here because the person can't get legal aid because of their wages, even though they might be on low income. And so I guess there's a slight chance there might be a decent quality charity in your area which can potentially provide kind of decent quality advocacy for you in that situation. But that is very much a postcode lottery, and I wouldn't put much money on it because a lot of charities really don't know this stuff at all. They don't know where to start. So maybe try a law centre. You could try ring a shelter. But again, obviously, every decent service is going to be completely overrun and overwhelmed by the level of need. If you've got the headspace for it, there is enough information on this channel to kind of work out what that test is, what that kind of definition is. I put a playlist up this week about vulnerability, so all the videos about vulnerability in a reasonably logical order. That's something which you might try. But yeah, and just I guess I'll say another couple of bits before I just open up to Shannon and Will. The fact that they work in, a lot of councils will see that and say, oh, you're fine, there's nothing wrong with you. That's not the test. The test isn't, are you well enough to work? The test is, what would happen to you if you became homeless? And they're two different things. Actually, I would argue that losing your job if you became homeless would be part of the harm that you could probably include in the kind of the composite test. So yeah, that's my answer. I've maybe got a bit more to say, but I just want to open up to Will and Shannon just to see if they can see anything else that I can't in this one.
I would add a couple of things. One is, I know it may be just the way that this is worded, but if the person's financial situation is such that they can't afford to rent in the private sector, then it may be that they are eligible for legal aid, and the fact that they're not getting benefits isn't determinative. You can, forgive me if you've done this test, but if you Google it and say, am I eligible for legal aid? There's a couple of sort of forms you can fill in. There's a government website where you can do the assessment. But essentially, if you've got a disposable income after you're paying your rent of £733 or less, sorry, less than 733, then you're eligible. Or if you've got less than eight, and if you've got less than 8,000 so savings. So here it says the person can't afford to live in the rent in the private sector, but it sounds like they are renting in the private sector, or they have been. So maybe they have been having financial problems, and they may not have such a big disposable income after paying the rent, which they're liable to pay at the moment, unless they've got a very cheap private sector place. So sorry if I'm tangling that up, but I'm just saying maybe double check that assumption that they can't get legal aid. And the other thing is the medical. I mean, we haven't really said what their medical condition is here, but if they've got a medical condition which means that they can't live in shared housing, it may be that they've got a more severe medical condition than the council have recognised. But as Mike said, that the problem is challenging priority need and vulnerability decisions isn't really about having a fair and rational debate about whether somebody's got a medical condition. It's like talking to a sort of angry child about whether they can get their own way or not. And the council, so if you say I've got X condition, we've talked about this before, they'll just say, well, yeah, X condition's bad, isn't it? But it's not as bad as Y condition. And so you're not that bad. So I would think have another look at the medical and try and request a review of the if they've done a negative section 184, have they? Or no, they've said that they're not in priority need, but so presumably a decision that may mean that it's been said in a section 184 notice, or it's just been, or a section 184 notice is on the way. But I would don't give up on that one. It sounds possible. And the other thing I'd say is, as Mike said, there's arguably the relief duty does apply to people who are not in priority need in a serious way, and that you do have to take serious steps to help them. You can't just say, well, we'll open a relief duty for 8 weeks, and oh dear, we didn't find anywhere. You have to say, well, what did you do in that 8 weeks? What was the housing needs assessment, and what was the personal housing plan? There have been challenges on that, but again, if you can't get a lawyer, it's difficult to run these technical arguments. But hopefully, the legal aid point may turn out to be not as bad as you think.
Cool. Thanks, Phil. And just so I've got it in my head correctly, so after paying your rent, if you've got less than £733 and you've got less than £8,000 in the bank, you will be eligible for legal aid. Like, have I heard that correctly?
Yeah, but where it says it's a disposable income of 733, which is a slightly deceptive term, because disposable income, people would say, well, does that mean after all my bills are paid? And that's common sense says, yes, that's what it means, but it doesn't. There's certain allowable deductions you can make. So there's your rent, there's allowances for your children and dependent partner, and a couple of other things. Like if you're working, you can get, I think it may have gone up recently, but it was £45 a month you can take off for work expenses, which again is hideously out of date when you think if you're working in central London and you have to travel there and back every day, it's probably going to cost you more than £45. But yes, it's basically, there's a key card which you can, if you type in legal aid eligibility key card into Google, it'll show you how to work it out.
Cool, that's helpful. Nice one, thanks, Phil. Yeah, and I think potentially as well, I guess we haven't said it yet, engage with your local politicians. So go talk to a councillor. I'm not saying it's going to be terribly helpful, but sometimes you'll get a councillor who's actually good at what they do, they know what they're doing, and they'll kind of see the issue as well. They'll kind of fight your case for you as well. So yeah, okay. Next question, which we're going through the live chat, because we've done the anonymized ones from the week. There are some more we haven't done yet, but we'll get to them at some point soon. Hey, right, Martin. Just seen you slipped in there. Cool. So Number 6, a person thinks he was treated unfairly by a housing officer, including being told some misleading information. What's the best way to make a formal complaint to the council? Thank you. So there's a video on the channel called The Best Way to Make a Complaint, which really kind of arguably the most important thing is to request a copy of your records. And the problem you might run into here is that the housing officer didn't record the misleading information that they gave you. And so it then becomes an issue of your word against the housing officers. And although that's not a completely hopeless kind of kind of aim, the odds are stacked against you in that situation. I'll give you an example I think I've used before on the channel where so my old colleague John at Just Us, he had a client who was basically that he approached the council when he had more than £16,000 worth of savings, and they basically said, you got too much, we can't, we've got, the person was in priority need. Oh, we can't get housing benefit for you, so there's nothing we can do. And what they didn't say was, when your savings go down below 16 grand, we can help you out, so come back. They didn't say that bit. So this guy ran all his savings down all the way to the ground. And he did get some compensation. He didn't get the full 16k, but he did get something. And so, bottom line is they are supposed to be giving you kind of legally sound advice. And if they don't, then they can be held accountable for it. But as I say, the problem you're going to find is proving it, because a housing officer's got to be pretty naive to record in their own notes that they gave misleading information. It's another reason why you should basically, if I was homeless, I wouldn't talk to them at all on the phone. I'd just put it all in an email, make sure it's all in an email trail. And if I did speak to them on the phone, I'd always follow up with an email saying, this is what you just told me. So you can kind of have that kind of contemporaneous sort of record of what happened. But yeah, so best way to make a complaint. I mean, again, if I was homeless and I had an issue, I would send it to the chief exec of the council. Make it very short. Use Chat GPT if it helps. Bullet, kind of number the kind of points you're making. Don't over egg it. Just kind of state it. You'll almost always get turned down on the stage 1, so don't worry if you do. Expect to go to at least stage 2. Probably go to the LGSCO. But the LGSCO have found in people's favour where, on the balance of probability, it does appear that the housing officer did in fact give misleading information. So as I say, it's not a completely hopeless cause, but yeah, it's question is, is it, I'm not saying is it worth it, but it might not actually resolve the situation that you need it to, plus that will take months. So yeah, that's my answer to that question. Not very positive, I appreciate. Chip in, Will or Shannon, if you've got anything else to add to that.
Just a really, really small thing, and it's probably in that video you've made, but making complaints can be quite like draining emotionally and stuff, and it can be quite like a lot to deal with. Um, it's such a small thing. If you've got like a calendar, either like paper or on your phone, just pop in your calendar the days that they're supposed to respond to you by, because I know personally I've made a complaint before for my own situation, and then it becomes too much and the date goes by, and then I've not responded to their response. And so just popping in the dates that they need to do their bits by and that you need to do your bits by can help you sort of keep track of everything.
Yeah, cool. That's helpful. That reminds me, I need to chase Somerset NHS Trust for those duty to refers. Yeah, cool. Thanks, Shannon. So yeah, hopefully there's some stuff in there which is useful. But yeah, it's not easy running through the complaints process, even if you're obviously right and you obviously have a good point. So yeah, question 7. Have I just missed that? No, I've got the right one. So council confirmed relief duty after the tenant received Section 21. It's been well over 56 days since the issue to Section 21. Would it be worth saying to the council that the property isn't suitable? Maybe. I'm just trying to work out.
That's what they mean.
Yeah. So would it be worth saying? Yeah. So okay. So it slightly depends on whether there's reasons to believe that you might be in priority needs. So priority need groups, obvious ones: dependent children, households with pregnant women in them, homes because of domestic abuse, and then you've got the whole vulnerability umbrella. There are some other ones as well, but they're kind of the big ones. And if there is reason to believe that you might be homeless, might be eligible, might be in priority need, the council should basically be offering you Section 188 interim accommodation pretty early on in the process, really, once the Section 21 is expired. So yeah, there's potentially some problems here in terms of like some obstacles that you're going to have. I think it's all, yes. I mean, to answer the question, yes, it's absolutely worth writing to the council saying, "Hey, I'm still in this unsuitable accommodation. What are you going to do?" But that may not be enough. I mean, it's so commonplace now for councils to tell people to wait until the bailiff comes and that sort of thing, that really you're going to have to make a very, I mean, I think even if people do complain, in most cases the council will probably just, kind of let you sit there and then potentially pay compensation down the line. So because it's essentially cheaper to do that than it is to actually, house you in the first place. So yeah, that I think, so I think the answer is yeah, make an issue of it, but bear in mind if you're not in priority need, then the council might just say, oh yeah, good point, you're over 56 days, we'll just close everything down anyway, and that'll be the end of it. So unless you're in priority need, then there's might be reasonably that you might be in priority need. There's not a whole lot that the council's actually going to have to do. As Will made the point earlier, they are supposed to do a whole lot of stuff in the relief period, but that seems to be pretty much not happening here. So yeah. Again, Will, Shannon, add in anything you want to add in there.
No,
If not, we'll go to the next. Right, cool. So number 8, and this is a two-parter, I believe. So no, I've just copied and pasted the wrong bit. Hold on. Let's try that again. What is going on here? Okay, some reason it's decided to do it in a different color. And there's a second part here. So, do you have any information about men's domestic abuse refuges, other domestic abuse shelters, and what type of long-term accommodation is offered after moving on from the refuge or shelter? Might so done be offered council housing moving on from domestic abuse. So, okay, so Mankind, I think, is probably the website you want to check out just to kind of get some information about refuges for men. What I do know about refuges for men is that there's 23,000 refuge places in England for domestic abuse survivors, and about 1,000 of them are for men. So there aren't a lot. I would argue though that so certainly if I was in that situation, having not been in it before, so I can't know for certain, but I would much prefer to make a homeless application in that situation than go to a refuge at all. And that's when I talk to a lot of people who've been through the system, that's also what they would say. So I'm not kind of just kind of making it up. And anyone who is homeless because of domestic abuse, and you have to kind of pay close attention to that wording. So if you're in accommodation and remaining in that accommodation is likely to lead to further domestic abuse, then you are legally homeless now, and you are automatically therefore in priority need now. You don't have to flee in order to make a homeless application, although often people obviously will. So you can approach any council in the country and they have to accept the application. There will be reasons to believe that you might be in priority need because of domestic abuse. So as long as there is also reason to believe that you might be eligible for assistance, as in have recourse to public funds, roughly speaking, then any council you approach in the country will have an immediate duty to house you in interim accommodation. That then gives you time for the council to make inquiries, for you to kind of gather information, and you don't have to go through the refuge process. And in my opinion, sorry for anyone working in refuges out there, lots of refuges wait for 3 months before they make a homeless application, and that just delays everything. If you're going into a refuge, make sure you're making an application in the first few days, as soon as you possibly can, basically, to the council you want to apply to. And you can remain in the refuge if you want to, rather than accept the interim accommodation. That's fine. If the council's, as long as you tell the council that's what you're doing, everyone wins in that situation. But by making a homeless application first, as soon as possible, rather than waiting for the normal move on policies, that is going to maximize your chance of getting house quickly. There is a video on this channel called The Best Way to Make a Homeless Application, which isn't terribly imaginative, but it does give you the steps you'd want to take, or I would want to take if I was in that situation, which largely kind of is kind of all making sure it's done in writing. So yeah, guys, anything to add to that, Shannon?
Just in regards to sort of suitability of TA, I guess, and it's probably covered in previous videos on the channel. But if you are a man that's been at risk of domestic abuse, it's probably not appropriate for you to share accommodation with the same gender, or to have shared accommodation at all. and that would be discrimination still. And there was something else I was going to say, and it's gone.
So just whilst you think about it, so if you're under 35, there's an exemption for the local housing allowance shared accommodation rate. So if you've ever been subject to domestic abuse, and there has to be a certain level of proof for this one, like a letter from a professional, then you basically get the one bed rate, even if you're under 35, just to say that. And I think also, I think that'll do for now. I mean, refuges also probably count as supported accommodation, so there might be an additional thing that might kick in down the line as well, but that's probably quite obscure.
Remember, so as well, just because I agree with yourself in terms of I would recommend sort of the Part 7 homeless application route over a refuge. But whilst one of the really important things to mention, and I know again it's mentioned in other videos, we've mentioned it before, but think about where you want to apply to. So if you're leaving an area, think sort of like if it's safe to take your time to think about where you want to go to, that's quite a big impact because you're sort of tied into the location and stuff. So
yeah, there's a video on the channel called "How Long Does It Take to Get Housed," which is I partly made that video. I basically got a bunch of stats from across England to give an average waiting time for people who owed the main duty, which if you're a victim of domestic abuse, you probably will be. And it just makes the point that the areas vary massively. So if you want to, if you want to approach a council in London, you can. They'll have a duty to house you probably, but if you want to get social, it's going to take a lot longer to get housed. That's the kind of the long and short of it. There is a bit more to it than that. But if you check that video out as well, you get an idea of, do you approach Kingston with an 87-year wait, or do you approach Bassett Law with a 6-day wait? All other things being equal, you might want to approach Bassett Law or other councils with a similarly low average. So cool. Next question, if this copy and paste function is going to work. Yes. So if an individual successfully appeals challenges a priority need decision due to vulnerability, domestic abuse, depression, anxiety, potential autism, and other neurodevelopmental issues, there's a bit more to it. After hold on. No, don't do that. This really doesn't like. I'm not actually being stupid at this point. Like this just doesn't like copy and pasting text particularly. After emergency interim accommodation, will they move on to and be offered council or private accommodation, or either? So it can be either. That's the short, quite long and short of it. Again, there's a video on the channel called "Will I Get Council Housing or Private Rented?" Something like that. So if you just search for the term council housing, you'll find it. There is no guarantee either way. So there is no way to guarantee getting social housing if you make a homeless application. It will vary. The likelihood will vary council to council, but you can still get private rented accommodation if it's a 12-month assured short-hold tenancy, and it's affordable and it's suitable and it's safe and everything else. Now, just to go back a little bit though, as I said earlier, domestic abuse, if you're homeless now because of domestic abuse, then it's an automatic characteristic. There are going to be some situations where you might historically be a victim of domestic abuse, but it's not your reason for being homeless this time. That's possible, in which case you'd have to rely on these issues here, vulnerability issues. But yeah, if it's a recent thing, if it's the reason you are now homeless, that is an automatic characteristic. You don't have to go any further. And the local government and social care ombudsman makes it clear that council's default position should be to believe people who disclose they've been abused. So you shouldn't need any proof. It's helpful to have it because it makes it smoother, but you shouldn't need it. So that's the other thing I kind of just pick up on that, to be honest. But yeah, I mean, these are all of these things are things which could lead someone to be vulnerable and therefore in priority need. I think I've answered that. Is that all right? Anything to add to that, guys?
Sorry, I feel like I'm being annoying. But just a small thing around sort of like, even if you're say like in priority need due to domestic abuse, potentially like the autism, other neurodevelopmental issues, and everything else, they might have an impact on the type of housing that would be suitable for you. And so it's clear to sort of, it's good to make clear to the council what sort of accommodation would be suitable for you and why, based on your disabilities under the Equality Act, and sort of, and any communications throughout that process. It's worth just putting into writing quite clearly for them.
Yeah, cool. Thanks, Shannon. There's another question which actually we've already answered it because Will was talking about legal aid earlier. So the question was asked before, Will answered it there. So I'm not going to put that one in there again. Yeah, we sort of explain, well, we'll explain the threshold of getting legal aid early when it comes to working. So next one, we've now been offered a property after being in main duty. I wanted to say thank you so much for your time and videos. They kept me sane in a very worrying time. Invaluable. Thanks very much for the feedback. Really kind of happy to hear that these videos yeah, kind of help people out. So yeah, appreciate you just kind of taking the time to come back to us on that one. And we wish you all the best really. I mean, I guess it's probably worth just saying check out your local charities and kind of council because there might be little grants available for you if you're setting up your home. So depending where you are, it varies massively. But certainly Bedford is an example where me and Shannon are. There's actually quite a lot of funding and kind of grants and stuff out there for people who are just kind of moving into the home for the first time to kind of help with furniture and kind of white goods and that sort of thing. So just kind of keep an eye out for that in the sort of local charity kind of sector or whatever. Cool. Next one. So, really fun. It's useful. Under main duty, ask for review under section 202. The council now ignoring emails and calls have contacted Virgo for legal aid. Any further advice? So, yeah, I mean, Virgos will be probably at capacity at the moment, but they will get to you. I'm going to guess. Will is that? Yeah. So just maybe kind of just hold on a little bit longer because I think Karis is off work this week on a hollybobs or whatever. So, I mean, I guess under main duty and asking for review of section 202, I'm going to guess that means suitability of accommodation. I think, yeah, first thing is hold tight for Virgos. Secondly, if or simultaneous, if you want to, just start writing complaints to the chief exec because ignoring emails and so on is just not okay. Council's understaffed. Their things, their kind of departments deliberately to kind of avoid people, kind of actually having to house people. So it is it's not kind of like it's they're victims to this whole situation. They specifically choose not to resource those departments, so the staff can actually have capacity to email people back. So just complain to the chief exec. But yeah, I think my guess is just kind of hold tight for Virgos. I will the kind of the $1 million question: how are you guys doing in terms of capacity at the moment? Sounds like you've had a proper busy run recently, but
yeah, I mean we are, but without wishing to disclose confidential information, where capacity is good enough that the person who just sent that message is on the system and is being dealt with. So they're not on a waiting list. I think they're just waiting. Would like to know some answers before we get, because I did a video last week. Was it last week or this week about statements of case? And the problem for solicitors is we can't, and you can't really give people detailed advice until you've got detailed information. So the capacity we've got at the moment is okay. We are struggling. No, actually, we are struggling a little bit, but we're still coping. But it takes a little while. Once somebody signs up and we say yes, we'll take on your case, it can take another week or so till we can actually advise. Because the first thing we have to do is get confirmation that they're eligible for legal aid, which then the legal aid agency require proof like bank statements and things. So we have to get all that. And then we have to ask for information and then do a statement. So hopefully once we've got all that, we can then give advice.
Cool. Nice one. Okay. Yeah. Next question. And I'm going to call time on new questions in the chat. So hold on. In the live chat this week from this point. So if you've asked your question already, we'll get to it. If not, we'll roll it. Well, you'll roll it to next week. So next question is this one here, which you're going to think is a two-parter. So if an individual appealing, challenging a non-priority decision due to vulnerability gets an assessment to determine potential autism, Asperger's syndrome, ADHD, OCD, etc., paid for under legal aid with the help of a housing solicitor, gets a negative diagnosis for these conditions, can the legal aid housing solicitor facilitate a second assessment opinion from a different assessment clinic? So I don't know the answer to this, but will. My guess is no,
Yeah.
but I don't know, I might be wrong.
Well,
Will?
if the assessment is from an objective, sort of neutral clinic that has assessed somebody and said you don't have a condition, unless there's some very good reason for thinking that assessment is defective, the legal aid agency wouldn't fund another one and say, well, let's go and see if we can get somebody different to say something different. But on the other hand, if the assessment was by Now Medical, for instance, as part of the homelessness application process, so the council said, we've assessed you and we don't think you've got a problem, then you could definitely get a report. But it sounds here that as if the person has got an assessment. But then again, if sometimes you get this, that people who are on low incomes go to independent private sector health people to get reports. And they're not, because they're not charging a lot, they're not necessarily very good. So you could say, well, this is just a load of rubbish, this report. Say, for instance, this morning I got a report in on whether a client had mental health problems and didn't have capacity. And that was from a consultant psychiatrist, cost £1,100. So it may be that if you only had £100 to spend, you might get something that was bad. But I mean, if it was a good report from somebody that is, you've been referred to by your GP and they've done an assessment and said, no, we don't think there's a condition, I don't think a solicitor could just go along and say, well, let's see if we can get some different medical evidence. Although you could ask the questions to the person that had done the assessment if they may have made a mistake. But as a starting point, it would be quite difficult to go in there and say we're just going to get our own medical evidence.
Yeah. Okay. There's just an additional question which I will kind of cover about eligibility for legal aid. So there's a question about the number of hours you work, but my understanding is the number of hours is not relevant. It's about how much you're actually earning and whether you've got this so-called disposable income. So
Yeah.
if you're working, like minimum wage, it's obviously going to be more hours than it would be if you're working a high paid position or whatever. So yeah, I think that's the answer. So as I say, guys, no more questions, no further questions in the live chat. This will be the last one. Is it worth registering with two different councils as homeless for higher priority on housing register? I have local connection to both. You can do it. However, my understanding is that although you can make homeless application to more than one council, you can do it to many councils if you want to. At some point in time, they're going to funnel it down to one council. I think I've never seen it really, but I think they're going to make you choose and say, look, you've approached two councils here. They agree on which council is going to be the lead one in terms of carrying out inquiries. My guess is at some point they're going to say, well, I think they are. I don't know. But I think they're going to say, look, you need to make a decision which one do you want to go to. But I'm not actually basing that on anything I've read legally, so I might be wrong about that. But I'd probably say I get why you want to do it, and you can do it. You do have to tell both councils that you've applied to the other one, so you can't just kind of do it secretively. One of the things you might do to maybe kind of work out is kind of the average waiting times for people owed the main duty, which again, I referred to that video earlier. You can kind of check out what your local council's averages are. They're only averages, and you do need to watch the whole video just to kind of get an idea of kind of everything. So yeah. I don't know. This might be one of the ones to roll over to another time. We do a bit of research. Do either of you guys know the answer to this? As I say, my gut is pragmatically, although you can start the process with more than one council, at some point they're going to basically hone into one council or the other. That's my understanding.
Yeah, the thing I'd say as a practical point is that you could, in theory, the way that the legislation is written and the code of guidance, I mean, I could spend a week going around 7 different, more. I could apply to every single local authority that I wanted to, and they would then have to, in theory, have to accept a homelessness application from me. At some point, they might have to say, well, we'll take into account the other 25 applications you've made to different councils. What conclusions they draw from that. If one of the councils gave me accommodation, they might then say, well, you're not homeless. But this is the practical problem. If I went to By the time I got to, let's just say for the sake of argument, local authority number 2, and I said, hello, I'm making an application. And they looked me up on the computer, and just supposing it came up that I'd already applied, they found my application to local authority number 1 on the system, which I think they do have systems they can talk to each other with. Then if they said, sorry, we're not going to help you, that would be unlawful. But if somebody came to me as a solicitor and said, can you judicially review council number 2? They're refusing to process my application. I would have to say to legal aid, I'd have to ask the legal aid agents to give me legal aid, and they'd say, well, why are they doing this? What are they going to benefit from applying to number 2 rather than number 1? And I'd have to say, well, nothing that I can think of, but technically they're allowed to do this. And so I think the legal aid agency would say, no, we're not going to fund that because there's no benefit to be gained from it. And a judge would certainly say, what are you doing here wasting my time? You actually want relief from the council. What is it you're looking to gain? And it isn't just some, academic point. Well, I wanted to prove that they all have to do it. They would say, well, if council number 1 is processing your application, if you've got a problem with temporary, you've got to challenge council number 1, not go to council number 2 and say, I'm still waiting to hear from council number 1. So I think it would be difficult. People would say you're just messing about. And unless and I think probably they'd be right in practical terms. So I hope that helps.
I mean, one thing's probably worth saying, Tiff, is that so Jan Luber, who's he writes the kind of the big fat textbook on the sector, which I think is the best one around, which is this one here. He basically he I don't know, he advises, but he kind of advocates for an approach. If you do get a negative decision from one council, then there's nothing to lose whatsoever by approaching a different council. Shannon kind of alluded to it earlier. And so that is possible, but that's not the same thing as approaching both councils at the same time. So because I mean, basically the reason Yanu was saying that is, but potentially you might get a more benevolent council the second time, and you might get a more positive decision from them. But yeah, I think you're going
add something to this, because today I've just been advising somebody, believe it or not, to make an application to a second local authority, and you may say, well, doesn't that go against what you just said? But there will be limited circumstances where this is necessary, and if I could just illustrate it. It's the thing I've gone on about before, which is when you've been found intentionally homeless, or if you've refused an offer and the council are refusing to help you, you're entitled to advice and assistance under section 190, yep, if you've got priority need. But in order to get priority need, you have to be found intentionally homeless. So if you're at the stage, and I've got a client who's at this stage, she refused an offer of accommodation from a council. They said, right, we're treating our duties as discharged and we're going to evict you. She goes back to the council before the eviction and says, well, I want to make a fresh application based on the fact that I'm now facing eviction. And I need, for one thing, I need to make this application in order to trigger my section 190 entitlement. And they've said, no, we're not going to accept a fresh homelessness application from you because your basis of your application is exactly the same as it was when we decided we didn't owe a duty to you. And arguably, they're right about that. There isn't a lot of change. I mean, common sense says, of course it isn't the same because she's now going to be evicted and you hadn't issued the warrant before. You've only issued the warrant because you made the decision. But that's much too much like common sense. So we've gone to the High Court to challenge the refusal to accept a fresh application. And they've got one of the best housing lawyers in London arguing that, or in the country, arguing that there's no duty to accept a fresh application. So I've said to her, okay, if we can't challenge that, what you'll have to do is apply to another authority where you have no local connection. And then they will have to pick up your application and then consider whether you have a local connection with another borough. And they will then say, yes, you do. You have a borough, one with this council that have just evicted you. So we're going to refer you to them. And then the council will then have to decide, do we accept this referral? But they don't want to do that because obviously they've been refusing to accept a new application. If they accept the referral, it would be very difficult for them to say, yes, we've accepted this referral, but we're not going to do anything with it. So that would be a way to challenge getting through the back door through that. But then if the local authority refused to accept a referral from the second authority, it'd be quite an interesting question as to whether the second authority would then have to help. I've forgotten what the process is, but there is an internal process for resolving disputes between authorities. And I think authority one would have to process it. But authority two would have to provide, if you need temporary accommodation, authority two would have to give you temporary accommodation because they have to house you under section 188, and that covers the period while they're waiting to see if a referral is accepted. Does that make sense?
Yeah, it does to me. I appreciate it.
Sorry.
I think for some people who are kind of completely new to this, it'd be like totally over the head. But I
Yeah.
think, but no, it's fascinating for me. I think, and raises a few more questions I might have for you at some other time, Will, because that sounds like an interesting case. But yeah, but I think, I mean, it doesn't change our kind of overriding thing, which is that, yeah, there's not usually any good reason to apply for two. I mean, I would argue in that situation, Will, that
That's an
they're not
exception
actually
to his rule.
they're not technically simultaneous, or they're not at the same stage. You know, you
No.
made an application to one, got some sort of negative outcome, then you're therefore approaching the council two, rather than just kind of like, without even knowing what's going on, just approaching two councils at exactly the same time. So, but yeah, interest. Yeah, so I think I might have more questions for you at a later date, Will, on that one. But let's keep going with this for the time being. For tonight. So, does sleeping in a tent mean I'm homeless or my choice? If I'm unemployed, no benefits. Okay, um, so that sounds like there's some myths at work here for this person. So, sleeping in a tent means you're homeless, but that's all it means. It has no bearing whatsoever about whether you're intentionally homeless. And more importantly, the question for someone in this situation would be: is there reason to believe they might be in priority need? So if you're homeless living in a tent, first thing you need to do is basically make a homeless application. If if you're in a tent, you might not have access to the internet, but if you can watch the video I did about the best way to make a homeless application, that just kind of gives you some ideas about what to expect and what you can do to increase the chance of getting housed. If you can find a decent charity that's out there that's actually willing to advocate for you, and unfortunately, a lot of street outreach teams are in a position where they're paid by the council, so they don't generally want to ruffle feathers. But if you can find someone to kind of root for you, then I think that's probably going to be really helpful as well. But yeah, in one sense, yeah, just because you're in a tent doesn't have any bearing on intentional homelessness. All it's saying is that you're legally homeless. That's it really. And unemployment again has no bearing. If you're not on benefits now, I would highly recommend applying for them, because it helps in a number of ways, not just the obvious one of actually getting some money. So yeah, 14. Where are we up to? Hold on, guys. Let me just dig this question out. So I know the answer to this, even though I don't know what it's actually about, because I don't know what a liability order is. But I think the answer is yes. So I want to find out if the council applied to a court for a liability order. Could I request a data subject to access request to confirm, disprove that they did not apply for the liability order? So my answer is I think so. The only reason they might not do is if, and again, I don't know enough about it. I've just done a quick Google, and it seems to involve things like childcare arrangements and kind of child payments, and that in turn could have some kind of relation to domestic abuse potentially, and that might, in theory, lead to a situation where the council might have a good reason to not provide that information if they felt that providing information might lead to an increased risk from a perpetrator. But I don't think that applies here. So yeah, it should, my understanding is it absolutely should be. There's only a few situations when a council does not have to disclose personal data if you ask for it, and I don't think this is one of them. But as I say, unless, yeah, I mean the kind of situations where they can basically not disclose stuff is things like where there's investigating crime or investigating fraud, that sort of thing, which again I don't think applies here. So I think the answer is yes. And what I definitely know is it doesn't cost anything to do a subject access request, so I'd suggest doing it anyway. That'd be my answer. Shannon?
Yeah, so I don't know anything about liability orders. But one of the things that often catches people out is obviously you can make a subject access request for your own information. If there's any information in there regarding other people, it should be redacted, and that will be when the council decides that they know data protection law and start redacting everything. So just to sort of bear that in mind, if it's because when we talk about like Part 7 homeless applications, we talk about households, but when we're talking about subject access requests, it's individuals. So you wouldn't be able to get the information on other people in your household. It's information that relates to you. So just to bear that in mind.
Yeah, cool. Anything to add to that, Will?
No.
Oh, cool. Okay. Number 15. Registered visually impaired by my local authority and have osteoarthritis and will be vulnerable to abuse on the streets due to previous offence. Will I be in priority needs? Short answer is most probably yes. But as we said earlier on in this live stream, it's not about your diagnoses or anything. It's not about any individual thing. You have to focus on what's going to happen to you if you become homeless. And I think I actually gave arthritis as an example earlier, where arthritis is probably the most obvious example, where being cold and sleeping on a concrete floor is going to make your arthritis symptoms worse. And there you kind of already have an argument there. You're vulnerable because there's an okay, so it's so annoying to kind of try and explain in a short period of time, but you basically have to have something which differentiates you from a healthy and robust person, which is the way the law talks about someone who has no conditions, they have no impairments, they have nothing at all. And the point being that if anyone becomes homeless, they're going to suffer some harm. But the question is there something about you which is going to mean that you experience more harm than a healthy and robust person would if homeless? That's kind of the test. Again, I'm sort of kind of garbling it slightly, but so yeah, I mean, you could focus. I mean, again, I'm just kind of focusing on the obvious one there. Someone who's visually impaired, again, is going to make them more vulnerable to being exploited. So yeah, the answer is probably yes, but it's not that simple. You need to present your kind of evidence in a way which is focusing on what happens to you if you become homeless and how you're going to be at more risk than a healthy and robust person would be if homeless. So again, I mean, check out the playlist on vulnerability on the channel because there's about 10 videos in there. There's like good few hours where we kind of talk it through in more detail. So next question, I really need to know what the housing cap is on universal credit for a disabled person. I'm going to have to move out and need to know what the price range I can look into. So if you search for the term local housing allowance and then your local authority's name, because it varies from district to district, you will then have like a breakdown of the maximum amount of money you can claim in the private rented sector. It doesn't apply to social housing. So, and it'll be like by breakdown, by bedroom breakdown, that sort of thing. So there'll be a figure for bed sit, 1 bed, 2 bed, 3 bed, 4 beds. So yeah, I think that's what the question's asking here, and that's the answer. Just you can basically Google it, and you'll be able to find a document. There's actually kind of you can get it in a number of sources where it will just kind of set out what the caps are on the amounts you can claim for universal credit for housing costs in the private rented sector. So last question for tonight. As I say, I know there's some more in the live chat, guys, but as I say, we've kind of called it time on that. So again, just to say to those people who are disappointed they haven't had their question asked, put it in a video on the comment on the channel. Any video, just put it as a new comment, anonymize it, and I'll then be able to pick up on it. So these final questions we're reading out now have come in through the week, and that's the only way you can guarantee getting a question answered in the weekly live stream. Oh, wrong one. So yeah, question 17, our final one for tonight. The council has issued an intentional homeless decision and they said the duties ended. I've been told to leave the interim accommodation. When I ask for a review, will they still make me leave the interim, nowhere else to go, or should I make a new application? So they have a power to house people whilst the review takes place, whilst the Section 202 review takes place, which is a fancy way of saying challenging the intentional decision. But there's two things have to be done. One is you have to ask to be housed, which isn't very difficult. You just say, can you house me whilst this review takes place? But crucially, you need to provide some information that's more than trivial that was not included in the original decision. And that will often be quite easy because council officers don't have the time to basically cover all the bases because they're actually just writing templates half the time. So that's not that always that hard. But yeah, so you need to provide some sort of information which could have a bearing on the decision. And if you do those two things, you should get housed whilst the review takes place. There is yeah, I think there was a kind of a third bit to it, which essentially, if you were to say, if you don't house me, I'm going to be street homeless, then again, that's kind of just makes the point that it's really important. Um, but I think in most cases that would probably apply anyway. So yeah, so that's my answer. Will or Shannon, do you have a further answer to add to that?
Well, at the expense of making a bad joke, this is the bit where I say, why don't you apply to a second authority? But I'm not going to say that because it's not the right advice. But what I do this a lot. I deal with this problem a lot. And so stop me if I go on too long because I know it's late. So the answer is they may tell you to leave the accommodation, even if you ask for a review. Um, what you have to do is formally request that they give you accommodation, and they've got a power to do that. Rather than Section 188 gives a mandatory duty to where they think they have reason to believe you're homeless and in priority need. But Section 1883 gives them a power or a discretion to provide you with accommodation. So you have to ask them to exercise that. Now, when this all started back in 1997, or when the 96 Act came in, there was a load of cases which said you had to actually prove that you can't just say, I've got a good case for review, give me temporary accommodation. You have to say why and what new information you've given them to make them change their minds, but also explain why it's particularly important for you not to be made homeless and what the impact would be. So what you need to do, and this is it's easier if you're a solicitor and you've got resources and training. First of all, you have to request a review. Second, you have to make detailed representations in support of the review to show why the decision's wrong. Then you have to make a second. I mean, I have 3 letters that go off each time this happens. The second letter is what's called an anti-Muhammad letter, which is a bit of an unfortunate term. I apologize to any Muslims, but it's not. It's because there was a case called Muhammad where they said you've got to make the request in a particular format. So you then say, please can I have temporary accommodation for the following reasons, blah, blah, blah. Then you have to send a judicial review pre-action letter to the council saying, I've requested a review, I've asked you to exercise your power, and I'm putting you on notice that if you don't exercise your power, I'm going to go to the High Court and ask for an order requiring you to exercise your power. And then there's a fourth bit where you send a copy of all that to the legal department. And very often they'll say, okay, yeah, we'll give it. But if you don't, if you just say, can I have accommodation? They'll say no, because you haven't made a formal request in the proper format, which most people don't know all that stuff I just said. The other thing to check, of course, is if you're in interim accommodation, which is a flat or somewhere self-contained rather than bed and breakfast, it may be that they will require you to leave, but they'll take legal proceedings, which could take a few months. Whereas the problem is if you're in a hostel or bed and breakfast, you get a note through your door saying you're out tomorrow. It's very difficult to challenge. Well, I mean, they can do that, but you have to get the request in as soon as you can to stop them doing that, because the only way to prevent them from keeping you homeless is to judicially review them. So I'm sorry if that was a bit garbled.
No, as I say, it's yeah, it's good to hear, really good to hear someone saying it.
But a new application won't actually do. I don't think that'll help. You've got to actually request a review and ask for temporary accommodation pending the review. And the same thing with an appeal. If they complete the review, you can ask for temporary accommodation pending the appeal, but that's another story, which I won't try and tell now. You probably mute me if I just.
Cool. Okay, nice one. Thanks, Shannon and Will. I think we're back. I'm back next week. I think. But yeah. Will, are you back on Monday?
I'll be back Monday. I'm afraid I won't be around next Thursday. But if you guys are around on Monday, it'd be great if we could try and get a session going then. I've been a bit bad the last 2 weeks. I knackered myself doing my video on statements. And so, but I'm feeling confident that I'll be okay for Monday.
Yeah, cool. Okay. Yeah, I should be around, I think. So yeah, cool. I think that's it. Hopefully this was helpful, guys. As always, keep it all in writing and keep it methodical. Just kind of work through one thing at a time. And yeah, the law is good overall, I'd say. It is, there is a lot of assistance contained within it. It's just councils don't follow it a lot of the time. So it's about just kind of pushing in, digging in against the council And again, a lot of people just by kind of initially digging in actually massively increase the chances of getting house. So yeah, hope you guys are all right, and hopefully see you next week. Shannon says in the chat there, so it's 7:30, usually Thursday, sometimes Wednesdays, but it was always 7:30. So yeah, hopefully see you soon.